law professor and KTRS legal analyst, and one heck of a good guy, Greg Willard. Professor, welcome back to Big 550 KTRS.
McGraw, good morning.
Thanks for joining us. First, let's start with this 4-4 tie. Explain to us what that means.
What that means is it's a strong example of where the court finds itself with the death of Justice Antonin Scalia. What the effect of a 4-4 vote is, which we had yesterday in the immigration case, is that the decision below, the decision of the Court of Appeals, stays in place. The other effect is, since it's a 4-4 tie, that 4-4 tie does not result in a new rule that is applicable nationwide. So the current decision of the Court of Appeals stands, but that 4-4 tie has a very limited effect otherwise.
So we keep calling it a 4-4 tie, but from what I understand, that's not entirely accurate because they didn't release their opinions. They didn't release who voted how. They just sort of said, this is a 4-4 vote. We'll see you later, right? That's basically what they said.
That's exactly what they did. The decision that is getting so much attention, the immigration decision, McGraw, it is all of one sentence. And as one observer yesterday noted, seldom have the hopes of so many been dashed by so few words. One sentence, no opinions, no dissents, no concurrences, as you and I have talked about. And that is basically the way the court handles tie votes, is there are no opinions. It is simply the decision below is affirmed by a vote of, in this case, 4-4.
Do they have plans to bring it back? How does that work?
Technically, it could possibly come back. I think it is highly unlikely. There is a procedure in the Supreme Court known as a petition for rehearing. The Obama administration could ask for a rehearing. Those are rarely granted, and I would not expect it to be granted in this case. It happens, but I think for now we have heard the last from the Supreme Court on this particular immigration litigation.
Okay, so they're going to let the lower court decision stand. Now let's go to what the decision actually was and what they're telling President Obama he can't do, because that's an interesting story in and of itself. What did President
It is, McGraw.
Go ahead.
The backstory is this. President Obama has become, and a lot of leaders have become increasingly frustrated with the inability of Congress to pass immigration reform. We have 11 million people who are estimated to be in this country in violation of our laws, illegal immigrants, as they're sometimes referred to. In 2010, President Obama issued an executive order, and he unilaterally declared that he was not going to deport approximately 1.5 million children who were here illegally. In 2012, he expanded that to include about 5 million adults. And the unilateral action he took in 2012, McGraw, was in two parts, and those two parts are critical to what happened yesterday in the Supreme Court. The first part was that he announced that he was going to defer the deportation of those 5 million adults. In addition, he announced that he was going to give them certain work permits and federal and state law benefits. 26 states sued President Obama and his administration and said what you are doing is unconstitutional, and it also violates a federal statute, the Administrative Procedures Act. A federal judge in Texas entered an injunction and enjoined the Obama administration from implementing that program. It was appealed to the Fifth Circuit Court of Appeals, and the Fifth Circuit Court of Appeals affirmed that injunction. That decision by the Fifth Circuit went to the Supreme Court, and yesterday, by a vote of 4-4, the decision of the Fifth Circuit was affirmed. The consequence of that, I think, is important because while this was a blow to President Obama, it's not as big a blow, in my judgment, McGraw, as the commentators are making it out to be.
Okay.
Number one, the president's decision not to deport those 5 million adults, that's unaffected by what happened yesterday, because the court did not rule and issue an opinion that what he had done by deferring this deportation was unconstitutional. The injunction, which granted the benefits and the work permits, that was affirmed. That is what is so harmful, if you will, to the Obama administration, because his goal to bring these folks out of the shadows has been thwarted, because there's an injunction which prohibits the Obama administration from giving them work permits and other federal and state government benefits. But again, to be clear, what the decision yesterday did not say is that, Mr. President, you have to immediately rescind your deferred deportation order and start deporting those folks.
So if I understand you correctly, and as you've explained before in previous sessions, that the government doesn't have all the money in the world to carry out every law and every rule. So they sort of put an emphasis, and President Obama said, hey, emphasize this as opposed to these. And so that has stayed the law of the land, if you will. Right.
And that goes back to George Washington, McGraw. It's known as prosecutorial discretion, that the executive has discretion, for example, to in a drug crime. Do you charge the person with possession of a weapon and possession of drugs, or do you use discretion and say, no, we're just going to charge the drug crime? What President Obama has said is, it's up to me to prioritize who, what, when, where, how people are deported. And I have decided that this is what I'm going to do. The 26 states said, wait a second. It's one thing if you're deciding whether to deport a family or a small group of families. That's one thing. But when you are deciding unilaterally not to deport 5 million people who are here in violation of federal law, presumably, that's not prosecutorial discretion. That's going back to the days of King George, and that's unconstitutional, Mr. President.
Okay, Greg Willard is with us. So interesting to listen to you. Might even be worth going to law school to listen to you at St. Louis University Law School. But and I'm going to ask a terrible question, but hopefully I explain it well enough or ask it well enough that you can sort of answer it for me. And that is this. I understand we live in the world of politics. And I understand that the Supreme Court tries to avoid the politics and looks at the actual issue. And so we find all sorts of interesting rulings and things that don't necessarily follow along traditional political lines. But it's fascinating to me that as divided as this court is, and even though we don't know who voted 4-4, we can sort of guess. And so let's assume we can get a general idea. Isn't it amazing that the conservatives always line up against the liberal Democratic president these days, and the liberals usually line up in favor of the liberal Democratic president?
Well, I don't disagree. It's and it's why there's so much controversy with the nomination of Judge Merrick Garland to be Justice Scalia's successor. But I would caution you from taking that too far, McGraw, because yesterday, at the same time that this decision was issued on the immigration, the court also issued a decision and opinions in an affirmative action case out of the University of Texas. And the swing vote with the liberals on the court, the swing vote who decided the issue was Justice Kennedy, an appointee of President Reagan. So, yes, I would agree with you that in broad strokes, there tends to be a commonality of positions, if you will, between the more conservative justices and the more liberal justices, but that is not always the case. There was a decision recently also that Justice Breyer aligned himself with the conservatives, much to the dismay of a number of commentators. But on the immigration decision, I think it's interesting. We'll never know, but I think it's interesting to just think for a moment about the process that went into this decision that led to the 4-4 tie. There was oral argument several months ago of this decision. After oral argument, later that week, the justices sit down and they take a vote in conference. And they go around and see what the vote is on what the decision will be. Well, one has to assume that the vote was 4-4. Well, then normally you would expect that decision to come out the following week. In this case, it did not. And I think what that tells us, McGraw, is there was an extensive amount of work and discussion and deliberation among the justices to see if they could come to a consensus of 5-3, on whichever side the 5 would fall.
Right.
And as we found out yesterday morning, they were unable to do that, and the vote was 4-4.
So reading the tea leaves, you are speculating, which we love to do, that they tried to find a way out, and the 8 people who voted were so entrenched that they couldn't see through it to change their minds.
I think the time delay between what would have been the vote in conference and then the vote, the issuance of the decision, I think leads, not with certainty,
right,
but I think with a high probability that the 8 justices worked very hard to see if they could come up with a definitive ruling on at least one, if not both of those issues. And for absolutely legitimate, good faith reasons,
right,
they simply were unable to do so. They issued then a 4-4 opinion.
Wow. A
4-4 decision, which served to affirm the Fifth Circuit's affirmance of the injunction.
The Texas case was 4-3. Who held themselves out of that vote?
Justice Kagan recused herself, McGraw. Mm-hmm. She was previously Solicitor General of the United States at the Justice Department, and she had some involvement in this Fisher versus the University of Texas case. It has been in the courts for a number of years, and to her credit, not surprisingly, she very early on recused herself. Therefore, 7 justices considered the issue, and as I said a moment ago, Justice Kennedy was the justice who wrote the opinion for the majority of 4, finding that the affirmative action program that is utilized in the University of Texas system was and is constitutional.
Greg Willard, can you hold on through the break? I have a couple more questions for you.
I'd be delighted to, my friend.
That is Professor Greg Willard, St. Louis University law professor, former attorney for President Gerald Ford, and he is our legal analyst, KTR's legal analyst, and he's going to come back. A couple more questions for him. 9:25 here, Big 550 KTRS. American Eagle Credit Union, ladies and gentlemen, for a limited time, they have a special rate for 18, 35, or 50-month CDs. You can earn a yield that tops the market. At American Eagle Credit Union, for example, you can earn 1.81 AYP on a 50-month CD. To find out how you get that, American Eagle Credit Union, go online, ameaglecu.org, ameaglecu.org. When you become a member, you get all the benefits, including these special rates for a CD, not to mention free bill pay, free debit, free everything else. So if you're looking to park some money in a CD, you know you haven't had that opportunity in a while, American Eagle Credit Union has some special rates for you. American Eagle Credit Union, ameaglecu.org.
This is McGraw Live on KPLR 11.2, STLtoday.com, and the Big 550 KTRS.
Here we go. St. Louis summer is here. Now is the best time to call Premier Heating and Cooling to make sure your air conditioner is ready for the season. Ask about the maintenance agreements. In fact, purchase a new American Standard heating and air conditioning system and receive up to $1,100 rebate or 0% APR for 36 months. Premier Heating and Cooling has over 25 years experience in residential and commercial HVAC. It is a family-owned business, and they work on all brands and all types of heating and cooling equipment. And besides making sure your air conditioning is working properly, do you suffer from allergies? They take care of your indoor air quality as well. So give Premier Heating and Cooling a call. They are at 636-916-1122. You can go online, premierheatingcooling.net, or find them on Facebook. Premier Heating and Cooling, in business for a quarter century for a good reason. Premier Heating and Cooling, 636-916-1122.
Join the thousands of drivers who've switched their auto insurance to AAA.
After comparing a few other rates, it was clear that AAA was our best place to be.
With AAA, you're more than a policyholder, you're a member. And members get more. For starters, you could save an average of $381 a year. You could save even more with great discounts. Call 800-460-9090 now for a free auto insurance quote.
I didn't know how easy it was to just switch auto insurance.
You could save an average of $381 a year. Call 800-460-9090 now for your free quote.
The story of my savings is a very happy one with a very happy ending.
Why wait? See how much money you could save on auto insurance. For your free quote, call 800-460-9090. AAA. So easy, so smart, so switch. AAA Insurance is underwritten by affiliate AAA Insurers. AAA membership requires a separate annual payment. $381 is the average from a 2015 multi-state survey of new auto insureds who switched to AAA and reported savings.
QL1, does Rocket Mortgage require me to fill out a bunch of paperwork? Negative control. Rocket Mortgage by Quicken Loans is the first on-demand mortgage machine that quickly imports your financial data. You can go through the entire mortgage approval process in minutes. That is fast, like rocket fast. It also works on any internet-ready device, so you can get a Rocket Mortgage at any time or place you choose. Over. 3, 2, 1. Rocket Mortgage at QuickenLoans.com. Push button, get mortgage.
Rocket.
Equal housing lender. Licensed in all 50 states. NMLSConsumerAccess.org number 3030.
Hello, Jay Randolph here for my friends at Broadway Ford Truck Sales. And here is Terry, the Vice President of Sales.
Thanks, Jay. Here at Broadway Ford Truck Sales, your business preferred network dealer, we offer a huge selection of new and used pickups, vans, and SUVs to get the job done right. Stop in and visit our dedicated, experienced service and parts personnel. Jay, where are we located?
Broadway Ford Truck Sales is located at 1506 South 7th Street in the Soulard Market area. Online at BroadwayTruck.com.
$929, Big 550, KTRS. Boy, I just feel myself getting smarter with him on the show. Greg Willard is with us, St. Louis University law professor, also KTRS legal analyst, joining us here because we're coming down to the end of the Supreme Court session, and he has all the insights. Greg, so next, are we expecting any big opinions to come out today?
No, I don't think there will be any opinions out today. There will probably be one more, what they call Opinion Day, McGraw, and I expect that to be next week.
And we're expecting some big things coming out of there, right?
Yeah, there are two in particular that are getting a lot of attention. One is the criminal conviction of the former Virginia governor, Mr. McDonald. He was convicted of a number of counts of public corruption, and he has appealed his conviction, and he was sentenced to prison, and he's appealed his conviction to the U.S. Supreme Court. If one can draw conclusions from the questions at oral argument, we may see a very, very groundbreaking opinion from the court on federal public corruption statutes. That is expected to be announced next week. In addition, I think one that will probably get the most emotional reaction, irrespective of how the court comes out, is a decision that's on appeal out of Texas again, dealing with a Texas statute that has specified very, very stringent requirements for abortion providers in Texas. The question before the court is whether those restrictions are an unconstitutional limit on the Roe v. Wade rights. The court announced in the 70s that the restrictions that the Texas legislature has adopted, whether those are unconstitutional in violation of a woman's right to choose under Roe v. Wade. As I say, McGraw, either way the court comes out, there will be a large segment of the body politic that is unhappy to the point of outraged. And I think probably next week at this time there will be a great cacophony in the public square on that decision.
And win, lose, or draw. There's a third option now because we're still at 8 justices.
It could be a 4-4, a 4-4 tie again. But again, the fact that it has gone this far into the term, if it's a 4-4 tie, the fact that it has gone this long into the term, and they haven't issued this decision suggests to me on both the McDonald case and the Texas abortion providers case that we can expect a decision. It may be
right.
Like the immigration decision that they're trying to cobble together a 5-3 decision and they will fail and tell us next week. I don't think so, McGraw. I think we're going to get a decision on the abortion provider case out of Texas.
All right, Greg Willard, last topic for you here, and that is, so they're not voting on Merrick Garland. They're waiting for the next presidential election in November. There have been some Republicans that have said blatantly, we're waiting for our guy to win. If our guy doesn't win, we'll take Merrick Garland over who Hillary nominates between the times that she wins the election and she's sworn in January. Is that possible? Can they do that? And does President Obama have the right to sort of take back his nomination? How does all that work?
Let's see. Let's break it down into the pieces there. Number one, the Senate can exercise its confirmation right at any time that the nomination is pending. President Obama has announced publicly, McGraw, that he will not withdraw Judge Garland's nomination. Therefore, that nomination will be sitting up at the Senate until noon on January 20th of 2017.
Now, he could change his mind and sort of take it back whenever he wanted, couldn't he?
Well, he could.
Okay.
He could, but I don't expect that to happen. I think he's dug in just as Senator McConnell and the Republicans have dug in.
Right.
So if Mrs. Clinton is elected president, which the polls suggest she will be, then the Republicans could make a calculation that we're probably not going to do any better and we could do a lot worse in their judgment than Merrick Garland, and they would then move quickly to confirm him, which would allow President Obama then the power to appoint Judge Garland to the Supreme Court before January 20th.
Boy, this... do we live in interesting times, or has it always been this interesting?
Well, what is going on now, I think, is unprecedented. But I guess maybe I take a contrarian view of this from a constitutional standpoint. A lot of people have been pounding the table adverse to the Republicans, saying this is outrageous, this is unconstitutional, this is terrible. I would take strong issue with that, not from a policy standpoint, but from a constitutional standpoint. This is exactly the checks and balances that you and I learned about in grade school, McGraw. This is exactly the checks and balances that the framers put into the Constitution. How the president uses his power to nominate, how the Senate uses its power then to confirm that nomination, that was specifically and intentionally left open in the Constitution. And so the fact that the Republicans who control the Senate have said, this is how we are going to use the Senate's power under the Constitution to decide whether to confirm, that is foursquare permissible under the Constitution. Whether you agree with it as a matter of policy, that's different. but it's permissible under the Constitution. And it's also permissible, I would suggest to you, McGraw, for a simple reason. This is why we have elections. If the American people do not like how the president is exercising his nomination power, if the American people do not like how the Senate is exercising its confirmation power, well, that's why we have elections. And we're going to have one, obviously, in November with a third of the Senate and the White House. And so let's see what the American people say. But to beat the bass drum in the parade and say that this is a constitutional abrogation by the Senate, I think is great political fodder and pretty weak in terms of constitutional bases.
Ladies and gentlemen, that will be $35,000 for a St. Louis University law professor. That's worth at least a couple of credits right there. Greg Willard, thank you very much for your time. Great insight as always. Have a good weekend. We'll talk to you next week.
Always good to be with you, my friend.
You got it. Greg Willard, ladies and gentlemen, one of the good guys, one of the really, really, really good guys. And we're thrilled that he joins us from time to time to help break down what is very often difficult subjects, but breaks it down so that even I can understand it. 9:37 here, Big 550.